Imagine a standoff where the leader of the nation wants to send in troops to quell unrest, but local leaders dig in their heels and say, "Not on our turf." That's the dramatic core of the clash unfolding right now, involving President Trump and the state of Illinois, and it's got everyone talking about the limits of presidential power. But here's where it gets really intriguing. Could this set a precedent that reshapes how federal authority interacts with state sovereignty forever? In a bold move, the Trump administration turned to the Supreme Court on Friday, urging the justices to lift a lower court's blockade on deploying National Guard troops in Illinois. This sets the stage for a high-stakes legal battle over whether a president can dispatch military forces into areas where local officials are firmly opposed. At the heart of it is a request for emergency relief from the Justice Department, aiming to overturn a district court ruling that had prevented the federalization and deployment of Illinois National Guard members. To put this in simpler terms, for those new to these concepts, federalization means the president takes control of the National Guard, typically under state command, and brings them under federal authority, much like calling up reserves for a national emergency. The administration argues this is essential to protect federal immigration officers and government assets from ongoing threats. But the courts have stepped in, saying the situation doesn't meet the legal threshold. An appeals court in the Seventh Circuit upheld a freeze on the actual deployment of these troops, though it allowed them to stay in federal service while the legal wrangling continues. Solicitor General D. John Sauer, representing the Justice Department, painted a stark picture in the Supreme Court filing. He claimed the lower court's decision undermines the president's role as commander-in-chief, essentially inserting judicial oversight into military decisions. In his words, it's like the court is trying to micromanage the president's choices on which forces to deploy and where. Sauer emphasized that blocking this move eviscerates Trump's decision to federalize about 300 Illinois National Guard members to shield DHS personnel from violence and ensure federal laws are enforced. He even extended this to up to 400 Texas Guard troops assisting in the Chicago region. And this is the part most people miss. The administration warns that without these troops, officers' lives and property are at risk, and it puts the courts in a tricky spot, potentially dictating military strategy. Trump has invoked Title 10 of the U.S. Code, a key law that lets the president activate state National Guard units for federal duty if there's evidence of rebellion or an inability to enforce laws with regular forces. Think of it as a constitutional tool for presidents during crises, but it's not used lightly. The White House contends that protests in cities like Chicago qualify as such threats, where violence against federal officials and facilities signals a danger of rebellion. For beginners, Title 10 is basically a section of federal law dating back to the country's founding, designed to give the executive branch flexibility in emergencies. In this case, the administration points to violence and the constant threat of violence in Chicago, arguing it hinders federal immigration enforcement and protection of officers from assaults or obstructions. They've highlighted incidents outside an immigrant detention processing center in Broadview, a Chicago suburb, as proof. But here's where it gets controversial. Illinois Governor J.B. Pritzker has blasted this as un-American, likening it to forcing military troops on a state against its will. He vowed on X, formerly Twitter, that Illinois will defend its state's autonomy. The state and Chicago sued, claiming the orders are illegal, while the administration insists courts shouldn't second-guess the president's call. Is this a necessary step to maintain order, or an overreach that erodes state rights? Some might argue it's a clever use of presidential authority to bypass local resistance, while others see it as a slippery slope toward federal overreach in domestic affairs. The legal saga kicked off with U.S. District Judge April Perry ruling that the Homeland Security Department's evaluation of Chicago's unrest was unreliable. A Seventh Circuit appeals panel then blocked the troop deployment temporarily, but allowed federal control to persist. In their Thursday decision, the judges unanimously stated that the protests, spirited and sometimes violent as they were, don't constitute a rebellion without more evidence. They noted that federal sites stayed operational and disruptions were managed by local and state forces without meeting this level of intervention. This isn't isolated to Illinois. Trump has federalized guard troops in places like Los Angeles, Portland, Memphis, Washington, D.C., and threatened action in Baltimore and San Francisco. Appeals courts have permitted some deployments, such as roughly 4,000 California troops in L.A., and are considering similar requests for Portland. As an example to illustrate the broader pattern, these moves often follow protests against Trump's immigration policies, raising questions about whether they're about public safety or political messaging. In wrapping this up, it's clear this case could redefine the balance of power in America. Do you think the president should have this kind of military leeway over state objections, or does it risk turning the U.S. into a nation where federal might trumps local voices? Is the administration's interpretation of rebellion fair, or are they stretching the law to fit their agenda? Share your thoughts in the comments. Do you side with the White House, the governor, or somewhere in between? Let's discuss.